you're about to bring a foreign loan into your Vietnam-based company. You've negotiated with the overseas lender. The term sheet is agreed. The contract is ready to sign. But before you do, it's worth pausing for a moment. Because a foreign loan agreement is not just a formality. It's a legal instrument that defines your rights, obligations, risks, and how regulators and banks will view the transaction. In this video, we'll walk through the key clauses you should review carefully before signing a foreign loan agreement, so you can avoid issues later and move forward with confidence. Let's start with the fundamentals. How much are you borrowing? In what currency? And when, exactly, will the funds be disbursed? A well-drafted foreign loan agreement should clearly state the principal amount, the loan currency, such as USD or EUR, and whether the funds will be disbursed in one lump sum or in multiple tranches. It should also specify the date of the first drawdown. That date matters, because under Vietnamese regulations it may trigger repayment timelines, reporting obligations, or registration requirements. If this clause is vague, you open the door to misunderstandings, exchange rate exposure, and potential compliance issues. Next, look closely at how the loan will be repaid. The agreement should clearly spell out the interest rate, whether fixed or variable, how interest is calculated, when interest payments are due, and how principal will be repaid. It should also specify the maturity date and what happens if payments are delayed. This is particularly important in Vietnam, because once a loan extends beyond certain thresholds, such as the 12-month mark, different regulatory rules may apply. Clear repayment terms help protect both your cash flow and your compliance position. Another clause that deserves attention is the purpose of the loan. The agreement should clearly state what the borrowed funds will be used for, whether that's investment, working capital, refinancing, or another permitted purpose. Vietnamese authorities often review the purpose of borrowing when assessing registration requirements and eligibility. If the agreement is silent or unclear, regulators may draw their own conclusions, and that can create complications. Aligning the stated purpose in the agreement with your actual use of funds and any required registrations is essential. Most foreign loan agreements include conditions that must be met before funds can be drawn. These conditions may include corporate approvals, licensing steps, loan registration, or the opening of a designated foreign loan account in Vietnam. A strong agreement will clearly list these conditions precedent, so everyone understands what needs to happen before money moves. If funds are disbursed before conditions are satisfied, the borrower may face regulatory or banking issues. That's why drawdown conditions should always be tied closely to compliance requirements. This is where the agreement becomes more serious. Key clauses here include borrower covenants, what the company commits to do or not do, events of default, and the remedies available to the lender if something goes wrong. Given the cross-border nature of the loan, it's also important to consider issues like currency transfer risk, regulatory compliance risk, and enforcement challenges. Clear, balanced drafting in this section helps avoid surprises and protects both sides. Even though the loan is used in Vietnam, the agreement may be governed by foreign law and subject to foreign dispute resolution. That can be acceptable, but it must be considered carefully in light of Vietnamese regulations. You should also review whether any assets in Vietnam are being used as security, and whether there are legal restrictions on granting security to foreign lenders. The agreement should clearly address governing law, dispute resolution mechanisms, and how enforcement would work in practice in Vietnam. Finally, think ahead. What happens if the loan needs to be extended? What if the interest rate changes? Or if the parties want to convert the loan into equity? The agreement should include clear mechanisms for amendments, extensions, and conversion, and should address how regulatory registrations or notifications will be handled. Failing to register required changes can expose the company to compliance risks or penalties. Planning for flexibility at the contract stage makes future changes far easier to manage. At LTS Law Firm, we assist clients with reviewing and drafting foreign loan agreements to ensure they align with Vietnamese regulations. We help identify key clauses that require attention, assess registration and reporting triggers, coordinate with banks and lenders, and anticipate future changes such as extensions or conversions. With the right legal review, your loan agreement becomes a tool that supports your business, not a trap that creates risk. If you're about to sign a foreign loan agreement, or if you've already signed one and want to check whether it's fully compliant, now is the time to act. Contact LTS Law Firm for a professional contract review. We'll go through your agreement clause by clause, align it with your regulatory obligations, and help you move forward with confidence. Visit www.lts.com.vn or get in touch with our legal team today. A loan is more than money. It's a legal commitment. Make sure you're ready before you sign.